Hello everybody, happy Thursday evening to everyone that's joining us tonight for another live Q&A inside our Partner Visa Secrets community Facebook group. So look, what I'll do is I think I'm just going to go straight into the questions. What we're finding is that the popularity of the group continues to increase exponentially. We're receiving close to 50 to 100 membership requests every day, which inevitably leads to more questions being asked inside the group, and which means I suppose there's more questions to answer during the weekly lives. So time is obviously limited, so I think I'm just going to get straight into it. So nice to see everyone. Matej, Secretsᵀᴹ, Mafe, Vivian. Thank you all for joining me tonight, and let's get into the info, shall we? So just to explain how this will go, ordinarily I do invite people to ask their questions in the thread, and that way I can answer them live for you. I will get to those questions as soon as I can. I want to get to the questions that were asked during the week first. I suppose in a first come, first serve style approach, and just to be fair and objective about which questions we answer and in what order. So I'll just quickly address this here. Sukta asked a question in the group regarding the Form 888's whether or not their daughter can witness the signature on the Form 888. Now, their daughter's a registered nurse, and as I mentioned to Sukta in my answer, there's no issue with being related, the person being related in terms of the person that's making the declaration on the Form 888 and the person who's witnessing the signature. It's just about the person who's witnessing the signature being an approved person to witness, and that is listed on page 1 of the Form 888. So there's a list of occupations that specify who can witness signatures. So it's not an issue being related, it's more about the qualifications and the position held by the person who's witnessing that form. So Sukta, I said I would address it in the live Q&A, so I held my promise. Adele's asked, how can I change my lawyer or take care of my case by myself? Adele, I asked whether or not that case has already been submitted or whether it was still in the process of being prepared. If the application's already been submitted, you can notify the department that you wish to withdraw the representation from your agent, or you can appoint another lawyer or agent and they can notify the department and let the department know that they are now your representatives and your authorized recipients. Ordinarily that can all be done online through the IMI account. Now, if your agent submitted the application inside their IMI account, you will need to import it first into your IMI account before you can do that. So there's a few steps in the process, but I just wanted to say that yes, you can change lawyers even after the application is lodged. I suppose I would just say, just be that in certain situations that may not necessarily be advisable. It's never necessarily a good thing to kind of change representation midway through your process, but if you're having problems with your agent or lawyer, yes, you can change. Now, Yana has asked, what is going on with prospective marriage visa processing times or averages as listed on the department website? Yana, and to anyone who is in the process of preparing a prospective marriage visa or has submitted a prospective marriage visa and is waiting, and look, we have many clients ourselves that are in the same position, same boat. The official, I suppose, word from the department is that prospective marriage visas aren't being processed at the moment because prospective marriage visa holders aren't exempt from the travel bans, from the travel exemptions. So therefore, they're not going to be approving them during this period. However, that doesn't mean that they won't be processed in the background, or it doesn't mean they're not going to be processed or granted at some point in future. It just means that they're just not granting them at the moment. In terms of what this specifically means, unavailable due to low volume of applications, I did address this in last week's Q&A. My opinion is that that's not accurate. It's not that there's a low volume of applications. It's just that the department don't have enough data to tell you how long they're going to take now, given that we are anticipating that all processing times will take much longer than they ever have before with any type of visa, but particularly partner visas. And that will apply equally, I think, to 820s, 309s, and prospective marriage visas. Arguably, perhaps, you would say prospective marriage visas might be the ones that are highest or the greatest impact, given that they're not being granted at the moment. But I do have to say that I think all partner visa type styles will be affected one way or another. So look, I think you just have to take that announcement or what the department has published on their website with a grain of salt. I wouldn't take it to heart necessarily, but you just have to understand that because they're not being processed or not being granted at the moment, it's going to have an effect on processing times. And I think that's just what the department are trying to say. They're saying it poorly and they're just using very vague language, but that's just what it means when you deal with the Department of Home Affairs. They typically use vague and non-specific language. You know, they can't tell you exactly how long a case is going to take in most instances. So I hope that answers that question, Yana. Unfortunately, it's not a good answer, in the sense that I can't fix the issue. There isn't a solution at the moment. We just unfortunately have to wait until COVID goes away and things start to go back to normal. Now, Helena's asked, application form and payment versus uploading evidence. Hi there, I'm applying for an offshore partner visa 309. I'm a bit confused about the fact that we need to fill in the application form and pay for the visa before we can access the page to upload our evidence. Yes, it is a bit counterintuitive. So my questions are the following. Do we need to have prepared most of our evidence, forms, photos before we actually pay for the visa? In the Q&A session, Martin seemed to say it was best to upload the evidence within a week of applying, so I imagine most of it would need to be prepared before applying. I suppose, Helen, the best approach when it comes to preparing a partner visa, now that's whether we're preparing partner visas for our clients or whether we're advising people how to prepare their own applications, you want to have your documentation and information organized. You want to have it ready on your computer. You want to have your documents named correctly. You want to be able to make sure that you've evidenced all the aspects of your relationship and that your evidence shows that you satisfy the criteria for the partner visa that you're applying for. So the problem is that if you haven't gone to that degree of organization and you're applying for the partner visa, you're kind of playing catch up in then trying to organize your documents that have to predate lodgement. It's all about time of application. I talk about that a lot in other videos, and I stress that point consistently. So being organized and having your evidence ready prior to lodgement means you're just going to have a better prepared application. Your relationship is going to be better evidence. But as I did say last week, you can upload your documents at any point after, but we do recommend that you upload it immediately after you apply. But the correct advice is that you want to have it all in line prior to lodgement. And that's how we approach our client cases. We make sure that we've evidenced their relationship as thoroughly as possible, and we feel that we just can't get any more from the couple, from our clients. We've extracted as much as we can from their documentation, and we feel that now it's ready to go. It's a comprehensive application. But technically speaking, sure, you can just submit the application without any documentation really, and you can attach things as you go after lodgement whilst the visa is processing, because it's going to take a very long time. But I just don't think that's the best way to approach the preparation of any visa for multiple reasons. Like I said, one, because you increase the likelihood of some issue at time of application, not having evidence the relationship properly, and two, if you forget to attach documents later, if the case is eventually picked up by a case officer without you knowing, they don't tell you when they're assessing your application, you run the risk of a department case officer making a decision without requesting more information or documents from you. They can make decisions without giving you another opportunity to provide more documents. So you just want to avoid that entirely. You just want to have everything ready. Submit with what you have, and then continue to upload and update your relationship evidence as the visa is processing. If so, how can we make sure that we are preparing the appropriate evidence in appropriate format since we can't access the uploading evidence page? Well, Helen, there are certain resources and tools that will help you do that. And the forms, until we have paid for the visa. I imagine we could look for some of the forms online, but I would hate to have prepared everything, then pay for the visa and realize that evidence does not fit the accepted format. Yes, that is the downside of how it works to deal with the department website, with the IMI account. You don't know what the forms are going to ask because you can't proceed through the rest of the form unless you're inserting dummy data, which is something else that I talk about in our live 3-day training. And yeah, you don't know necessarily what documentation you're going to need to attach because that's shown at the end. You don't know how to attach it or what category. Now, we do have products and solutions that help people through those issues. Namely, we have Visi, which is our DIY partner visa software that helps you prepare your best possible partner visa, and it does address those issues. It shows you what documentation you need, how it relates back to the criteria of the partner visa, how to rename your documentation. There's lessons in the lessons module about how to organize your documents on your desktop. And then we have a resource that's called our IMI upload guide, which shows you where to attach your documents in the IMI portal after you've applied. So, I mean, we do have resources and I'm happy to provide more information on how to get access to them. Just to explain now though, those that do attend our 3-day live training on the 22nd of June, at the end of the training, we will present some, I suppose, offers and packages for those that might be interested in using the software and the other resources that we have to, to help you prepare your partner visa. What is the date of lodgement of application? The date we pay for the visa or the day we upload our evidence? It's the date that you apply for the visa. As soon as you pay, you hit submit, you will receive your notification acknowledgement letter in your email, along with your bridging visa if you're applying from onshore, and your receipt. That is the date of application. So Helena, I hope that answers your question, or questions, I should say. Just making sure I haven't missed anyone, guys. So Vivian's asked, hi Martin, I've got a student visa until the 24th of June, 2020. Okay, so it expires this month. My partner and I would like to apply for the 82801. However, our relationship started on the 19th of June, 2019. So about a year from when you are approximately looking to apply. We are living together since October 2019 and we registered our relationship in May this year, so last month. Should we wait until the 19th of June to send the application? Is it too close to the expiry date? Or is it better to apply before and answer why our relationship length does not meet the minimum 12 months? Okay, so firstly, Vivian, if you have registered your relationship, the 12-month rule does not apply to you. So you don't need to worry about the 12-month rule. So just to explain, let's work through your timeline. So your visa expires on the 24th of June. 24th of June, 2020. Guys, let me know if you can't see my whiteboard. I'm not sure if I'm zoomed out too much, but we'll try. Just let me know. So this is Vivian's expiry date. All right, let's use a red pen. I like to be color coded. Right, this is an important date, an important milestone. Now, Vivian's asked, when should she apply for the visa? The relationship started in 19th June 2019, right? And she's asking about the 12-month rule, whether or not she needs to wait until the 19th of June 2020 to apply because of the 12-month rule. Now, as I said, Vivian, because you've registered your relationship, assuming it's registered in an appropriate state, and I suppose the main ones, the most common ones are New South Wales, Victoria, and Queensland. But if you live in other certain states and territories, you can still register. But I suppose I just have to put a bit of an asterisk there. It depends where you're registered. As long as your relationship is registered, you don't need to worry about the 12-month rule. It won't apply to you. It won't apply to your relationship because you have a civil union. Now, I did publish a recent Partner Visa Secrets episode on our YouTube channel, and it's specifically about the 12-month rule. 12-month rule. So I'll talk about it briefly here, but for a more in-depth analysis and summary of what the 12-month rule means and how to get around it, please go to our YouTube channel. There's a video there that will cover it in more detail. But because you've registered, it doesn't apply to you, okay? So that's the first bit of good news. The second question was, should you wait until the 19th of June to apply? Is it too soon to the expiry date? Look, Vivian, you have up until 11:59 p.m. on the 24th of June to submit your partner visa. So Hassan has just asked if we could zoom into the whiteboard. Okay, Hassan, I'm going to try. I can't promise that I'm not going to break this and disconnect everyone, but I'm going to give it a go. I might leave it, Hassan. I don't want to break it. But just let me know if you can't see it. And then what I'll do is I'm happy to print screenshots and post them to the group later. So Vivian asked, should she wait until the 19th of June to apply for a partner visa? Now, Vivian, as I was saying, you have until the 24th of June to apply for your visa, up until 11:59 p.m. Now, it's not advisable necessarily to wait up until that point. I would never suggest for people to do that. But the point is that, you do have time. You have until the 24th of June, 11:59 p.m. And another thing that I talk about consistently, another concept that I always reiterate is you want to use the time that you have left on your partner visa, on your existing visa, sorry, before you apply for your partner visa. You want to maximize the time you have left. You want to push back the time of application assessment of your relationship as far as you can. Now, if you have until the 24th of June, you're within your rights to apply on the 23rd, on the 22nd, on the 21st, and use the time you have from now until then to strengthen the facts of your relationship. Make sure that you're using your joint bank accounts properly. Make sure that you're collecting photos with friends and family. Make sure that you're getting written statements. Make sure that you're writing your relationship statements and write them properly. So use the time you have left to strengthen your case. So, you can wait up until the end of your visa to apply for your partner visa. I wouldn't suggest it, waiting until the 24th exactly. It's safe to apply a few days before. The only thing I have to say is every now and then the department website will just crash, it'll just be under maintenance, and we can never predict when that's going to happen. And that's why, I can't sit here and say wait up until 11:59 p.m. on the 24th of June, because if there's a system outage, you're going to run into problems. But the point is that you have time. So there's no issues with using what you have left and then applying for your partner visa. But it's not about the 12-month rule. That's not why I'm suggesting it, because the 12-month rule will not apply. It's just about showing that you are in a de facto relationship or married relationship if you're married, but de facto relationship when the visa is applied for. That's what's important. You want to show cohabitation, you want to show social aspects, you want to show financial, and you want to show the nature of your commitment. If those 4 aspects show that you are more than boyfriend, girlfriend at the time of application, that is how you prove you are de facto. Again, these are concepts that we talk about in a lot more detail in our live 3-day training, which will be held later this month. So, Helena, I think that answered your questions. My apologies if I missed. Sorry, Vivian, my apologies. I think that answered all your questions. Please let me know if I've missed anything. Annette, Anne. Hi guys, due to COVID situation, my friend and her partner are separated from each other. He lives in New South Wales and she's in Germany. Is there a chance they can register their relationship while being apart? Now, this is a question, and that you have to, I suppose, address to birth, deaths and marriages in the particular state that you're looking to apply for. I mean, it is a government department. They all have their own internal policy and process in terms of what it requires to register a relationship. So that's not a migration law question, or it's not covered under migration law. It's specifically within the policies of that birth, deaths and marriages office, or that state. So I suppose I have to palm that question off to the appropriate authority, which is birth, deaths and marriages. I'm quite new to all this, so this is J-Lo. I'm quite new to all this, so excuse my questions that you've probably heard 1,000 times. That's all right, J-Lo. I've heard all these questions 1,000 times even before reading your comments, so it's not a problem. That's what we're here to do. I'm an Oz citizen and my partner is living in Turkey, but is from Turkmenistan. We met overseas on a work contract that I was only contracted for 2 months last year in Asia. Sorry guys, I'm just trying to open this. It's just not letting me for whatever reason. When my contract finished, I went back to visit him a few weeks. We are doing long distance. Since the pandemic, my travel plans to revise. Jallo, I'm sorry, I don't know why it's not letting me open your entire thread. So I can't see all of your questions. It might be something to do with the window being open, but I'm just trying to see if I can close a few so it lets me. Let's see if this works. No. So look, I think, Jallo, I'm going to assume what the question is in relation to. I think you're going to ask, will the fact that you're separated have an impact on your partner visa? Or will the fact that you're separated have an impact on you meeting the criteria for the partner visa, being able to show that you're in a de facto relationship for 12 months? I'm going to assume it's somewhere around that. Look, Jallo, there is a difference between being in a relationship for 12 months and being in a de facto relationship for 12 months. And again, I do have to say that the best resource that I can push you towards is going to be the YouTube video that we just released. It's episode 3 of Partner Visa Secrets. and it covers the 12-month rule. And in that video, I do explain, there is a difference between showing you are in a de facto relationship for 12 months versus being in a relationship for 12 months. So being long distance is not an issue. It doesn't mean that you're not in a relationship. It just does have real practical effects on being able to show that you have been de facto for long enough. Because when you're not living together, you're missing a very key component of being de facto. Because cohabitating has a lot of indirect impacts. It affects the other aspects of the relationship. If you're cohabitating, you're able to, you're likely pooling your finances in one way or another to pay for your rent, to pay for the bills of that property. If you're living together, you have more mail that shows that you have, put your names together on more things. So, being separated doesn't mean that you won't meet the criteria for certain visas, but it does have an impact on being able to claim that you are or have been de facto for a long period of time. So, Jello, I hope that was in relation to what your question was. My apologies if I've missed the question.